persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 16-1325 et al. MISO Transmission Owners et al. Petitioners versus Federal Energy Regulatory Commission.
Good morning, counsel. The court thanks counsel for your patience and flexibility this morning while we dealt with some unforeseen issues, but we're ready to go now. And Mr. Jones, please proceed when you're ready.
Thank you. Good morning, Your Honor, and may it please the court. Christopher Jones for the transmission owner petitioners. I will be addressing the backdating issue, and my colleague, Mr. Bennett, will argue the successive complaint issue. I have asked the courtroom deputy to reserve 3 minutes for rebuttal. FERC's effort to backdate new rates, in this case 3.5 years, was unlawful and should be vacated and remanded to the commission to make the new rate of 10.02% prospective only from May 2020, accepting only the refunds required for the 15-month period beginning November 2013. Under Section 206 of the Federal Power Act, FERC is only empowered to fix a new rate to be thereafter observed, that is, prospectively, at the conclusion of the rate proceeding. Opinion 551 simply wasn't the end of the case. Now, FERC's general remedial authority in Section 309 of the Power Act cannot read into Section 206. The very retroactive authority the retroactive authority Congress kept out of FERC's reach in Section 206. Now, in this court's 2017 TNA decision, the court described it as, quote, obvious that, quote, any action FERC takes under Section 309 must conform with the purposes and policies of Congress and, quote, cannot be used to supersede specific statutory strictures. We contend that FERC's orders under review did exactly that by violating 2 specific statutory strictures by ordering 50 months of refunds despite a statutory 15-month limit and purporting to backdate a rate 3.5 years despite a statutory prohibition on retroactivity. Now, before I address FERC's legal error justification, I'd first like to address the specific statutory strictures in Section 206. 206, as amended in 1988, speaks with an unusually clear voice on the topic of rate changes and remedies. It permits FERC to provide rate relief in only 2 ways and at the conclusion of the case. Under Section 206A, after a hearing and after finding the existing rate unjust and unreasonable, FERC may then identify the new just and reasonable rate to be thereafter observed. The statute thus necessarily excludes retroactive fixing of new rates. Relief only comes at the end of the adjudicatory process. And if I might take a moment to walk through the timeline of what happened, beginning with Opinion 551. When Opinion 551 issued, rehearing was requested by both sides within 30 days. And FERC issued an order on November 28th, 2016, granting rehearing, agreeing to rehear the case, granting rehearing for further consideration, one of the now infamous tolling orders the court will remember from the Allegheny defense case. So within 60 days of issuing Opinion 551, the commission had already taken back the case and agreed to rehear it. That was 5 months before this court would issue the Amerimain decision. Now, fast forward to the 2018 briefing order, the commission then opened a paper hearing on all aspects of the ROE methodology. That's at Joint Appendix page 325, and acknowledged that that was part of a, quote, ongoing adjudication. Now, I would note parenthetically that over 2,200 pages of material was submitted to the commission after the briefing order issued. But it was not until Opinion 569 and then subsequently in 569A settled on a rate of 10.02%. Rehearing was subsequently denied in Opinion 569B, making the 569A determination the first final agency action that would have been subject to this court's review and fixing for the first time the rate to be thereafter observed. FERC offers no support for treating the act of fixing a new rate as a 3.5-year continuing process and seeks to backdate it to 551 based on the notion that merely that the order issued at that time. But whatever 551 was, what it wasn't was the conclusion of the rate proceeding. Now, Section 206B provides customers a very specific remedy also at the conclusion of the proceeding to address the duration of the rate litigation in the forms of refunds for a 15-month period, and thus necessarily excludes refunds for any longer period. This is the sole statutory remedy that customers have for paying a challenged rate during the pendency of a rate proceeding, no matter how long that may take. Now, the 1988 Regulatory Fairness Act was, in that respect, a careful balancing of two competing objectives. On the one hand, customers seeking protection from the challenged rate during the pendency of rate litigation, and the need for public utilities to know the rates they're charging.
Your argument seems pretty plausible based on the four corners of 206, both the general requirement of prospectivity and the somewhat reticulated nature of the refund remedy provided for. But this court has said that 309 has is an independent grant of authority and supports correction of legal error in the sense of you have a first order that makes a legal error, then you have a second order that corrects it and makes the relief retroactive to the date of the first order creating the error. And we've said that's just correcting legal. The requirement of prospectivity doesn't generally limit FERC's ability to correct its own errors. So, it's a little bit more complicated than just saying 206 covers the universe. And the way I was thinking of this question is the real question is, has FERC gone beyond simply correcting a legal error here? I mean, they have corrected a legal error in the later order, but arguably they've done a lot more than that. So how should we think of, is that the right framing, and what's the right answer?
It is, Your Honor. And as to the interaction between Section 309 and 206, and that is ultimately what the case is about. This court's precedent on 309 says if we're going to use it to interact with another part of the statute, it must, quote, carry out, and those are the words of Section 309, it must carry out some other provisions of the statute. So even in those orders that lay out a fairly permissive view and broad view of Section 309, understand that they have to be tethered to some other part of the statute. And I would, again, point to TNA is a good example of that. This court just a few years ago, again, arguably took what was an expansive view of 309 in that case, but tethered it to and noted that it had to be tethered to specific, empowering other specific portions of the statute. The Verso case is a good example of that. It's where this court said the 15-month refund period would be gutted if we couldn't then go forth and surcharge other parties to pay for the refunds. So in order to effectuate 206B, the court found that 309 was appropriate to issue surcharges in that case, again, to give effect to the part of the statute. Now, Your Honor, to your question.
What about Tennessee Valley, which seems to me the strongest case on FERC's side on this question?
Your Honor, Tennessee would suggest, the language would suggest a broad permissive reading, to be sure. But first of all, it wasn't grounded in Section 309. It's a 1972 case under the Gas Act that didn't really deal with FERC's remedial authority per se. It seemed to read into the statute, arguably under Section 5, the ability to go back and correct errors. But we think,
it's loosey-goosey, consistent with the times, no doubt. But doesn't the Natural Gas Act have an equivalent of 309? I mean, we could fairly read it as resting on that principle.
It does. It's Section 16 of the Gas Act is the corollary to 309.
So, right. So charitably read, the court is saying that provision permitted a second refund period, which was keyed not to the 206 equivalent refund, but to the idea that the court could undo the delay caused by FERC's erroneous dismissal of the the Natural Gas Act equivalent of the 206 complaint.
Well, Your Honor, a couple of things. I actually don't read Tennessee to be grounded in Section 16 of the Gas Act, the corollary to 309. It seems to read the retroactivity as somehow inherent in Section 5, which translated to the Power Act. And this is important. This court obviously does typically refer back and forth between the Gas Act and the Power Act. The Power Act is critically different by virtue of the 1988 Regulatory Fairness Act, which added the specific remedy. The Gas Act does not have a corollary to Section 206B. There is no 15-month refund. So to the extent there was any ambiguity in the Power Act at all about retroactive relief under Section 206, we think Congress absolutely answered that in Section 206B. Now, I would like to go back to your question, Your Honor, about, did the commission simply go too far? We think they did. To the extent that 551 was in fact error, we would argue it was incomplete error. They hadn't yet completed the agency process. As I mentioned, rehearing was outstanding. Rehearing had been granted for purposes of further consideration. The case was absolutely clearly open. And the commission then decided to have another hearing. And when it did so, it went, in our view, beyond the four corners of what could reasonably be construed as correcting the legal error. It decided to implement a rate methodology that was entirely different than the one they had before. And in fact,
they had to come up with a new rate, right? I mean, so it was predictable that something new was going to happen. I take your point that a lot happened, but something new was going to happen. And can I ask you the following hypothetical? So suppose you had a situation, and to try to bring it as close to this case as possible, suppose the commission saw what could happen in Maine at the time of the 551 order, and they just said, based on what we think the law is, here's the rate that we come up with. And it's, what was it? I can't remember the rate at that juncture in time. Was it that 10.32? I get the various ones confused, but they put a rate in and they say, but we've heard the oral argument, let's say, in Maine, and we see where that might be going. And so as an alternative, if it turns out that that's the law, then the alternate rate would be rate B, 10.02. And then if they did that, and then Maine comes down in the way that at least would have been forecast, then would it count as correcting legal error then to switch and go to the alternate rate that FERC would have already said would eventuate if Maine came out in the way that it did?
I think in that situation, Your Honor, we would have to square the alternative rate scenario. You'd have two rates there, and I would argue that neither one at that point would have yet been fixed. So if the commission wants to reserve itself the ability to consider other issues going on in other cases, and that does warrant mention that Maine, of course, was not our case. There, the agency had completed its work. Here, it had not. So under your hypothetical, I think no, until we know the rate has been specified. And under your hypothetical, Your Honor, I believe there were two rates at play. Then I think
but they would have specified the first one. They just would have let the world know what the second one, what the alternate rate would be if things went in the direction that they forecast they could. They didn't think they would, but they forecast they could.
Right. And I think that's where sort of mere notice doesn't suffice to fix the rate. Rate fixing has to have some degree of precision to it as specificity. And I think that we learned from this court in some of the cases we briefed. And so under your hypothetical, if we've got two at play and the court then issues the Maine decision and the commission picks one, then it can be thereafter observed. But until it does that, again, then the way that 206A and B work together, customers bear the responsibility of for the challenged rate until the commission can then fix it. And I actually, as far as what the commission did as further evidence of not correcting rehearing, I would actually point the court to Joint Appendix 11, 18, and 19, where now Chairman Glick, when chastising the commission for taking so long, describes the commission's process as adding new models, removing some models, tweaking some models, introducing new inputs, modifying existing inputs, introducing new screens, modifying existing screens, and even altering the way the commission places the ROE within the zone of reasonableness. All of those things happened after Maine. So to the extent that Maine even changed the way the commission thought about this case, it clearly decided to go off in a very different direction and go far beyond the four corners of what could reasonably be considered.
Oh, go ahead, Judge Walker.
No, you please continue.
I was going to go in a different direction. So if you're on this, please ask.
No, you go for it.
Okay. Can I just take you in a little bit of a different direction. And let's assume, just for argument's sake, and I know you're going to resist this assumption, but I just ask you to assume it just so I can understand how the different pieces of this case fit together. Let's assume that we vacate the 10.02 rate because we agree with at least some aspect of the customer's challenges. If we were to do that, then would this piece of the case go away? Because the question on this piece of the case is it appropriate to order a backward-looking refund to account for the difference between the 10.02 and the rate that was existing beforehand? And once 10.02 gets vacated, then the commission has to go back and come up with a new rate. And if we're in that hypothetical scenario, then it seems to me that the questions about a refund that's predicated on a rate that would have been vacated then go away, because we don't know what's going to happen on remand. We don't know what's going to happen on remand.
Right. So I guess, Your Honor, in that situation, again, assuming that you decide that 10.02 is too high and send it back to the commission, obviously it's a different fact pattern than we have, because the commission has in this case completed its work. But I think the only way to square it with the statute is that new rate would still have to be thereafter observed. The duration of litigation, as this court knows, has many components to it.
Well, I guess what I'm saying is, I mean, I think you're right that you would still have the same statutory argument, but we don't know that issue is even going to be presented, because once, by hypothesis, the rate gets vacated, then we don't know that this issue will surface again for sure. I mean, we can maybe predict that it will. Suppose the new rate is 10.32. Then there's not even a difference between the two rates. So you would never even have the question of a refund for the interim period as you do now.
Well, I guess, Your Honor, I think that's wrong. And the reason is, it's the challenge rate that becomes effective while the case is pending. And so no matter, in your hypothetical, even if we proceeded to then go fix a new rate, the issue remains that the commission would have to permit us to charge the challenge rate and recover that from customers through, and the settlements here are a little bit messy, to be clear. But I think the issue is still unavoidable. And so I don't think sending the rate back solves this question and necessarily moots it.
I don't understand how the issue is unavoidable. Like, well, how do we know that the issue is even going to necessarily be there? Because doesn't it depend on what the new rate is?
Unless the rate is higher than the challenge rate, which I think we can all concede is unlikely.
Well, first of all, just to stop you there, it might be unlikely, but that just may be practically unlikely, but it at least seems, we don't know for sure.
Fair enough. But at this point, Your Honor, what we have, the situation we have is the commission has ordered us, because the first order wasn't stayed on rehearing. We've been charging the 10.32. So some acknowledgement of what the law requires is necessary to then implement the remedy, I would argue, regardless of where the rate ends up, if that answers Your Honor's question.
I'm not sure that it does, because you may have been charging the 10.32. Have refunds been issued?
Refunds have been issued. So as soon as 551 started, we started charging, or it was issued rather, we started charging the 10.32. And then when 569 and 569A subsequently lowered that rate, we had to start the refund process, which I believe has largely been completed. So we are now sort of, we've now sort of effectuated retroactively the 10.02. So
what would happen then? Suppose, just hypothetically, maybe practically unlikely, but suppose that the 10.02 gets vacated and then it goes back to the commission, and the commission decides, based on the new analysis that's occasioned by whatever error hypothetically we would find, the rate is 10.32.
The rate is 10.32. So I think at that point, again, we would argue 10.32 is charged prospectively and 12.38 is charged during the interim. Well, right now we've been charging the 10.02 via the refunds, if that makes sense. So again, because we have been living in a 551 world since that order issued, it has to be cleaned up. And I don't know that the legal issue is entirely avoided as long as the commission believes it can backdate the result. Okay. I see I'm out of time, but Judge Walker, if you had a question, I'll defer to the court if I should continue.
Yes.
I think I can guess both of these answers, but you were charging the 10.02 3.2 rate beginning in 2016. Is that correct?
Yes, sir.
Okay. And if we had vacated that 2016 order, if we had vacated 551, then do you agree that FERC could have come up with a new rate and made it effective in 2016?
We don't. We think that even in that situation, the rate fixing would not yet have occurred. And again, to be clear, the fact that Amera is from a different case isn't the only thing that distinguishes it. I mean, we didn't yet have a completed agency process. So even in Your Honor's hypothetical, where you had vacated 551 on judicial review, we would have had a second order from the commission making those final determinations. So there's a critical procedural element that was missing. Again, we think that even if it was error in 551, it was incomplete error, and the commission, by granting rehearing and agreeing to rehear the case, took it back for itself and then didn't complete it until 2020.
Do you think you had notice after 2016 that FERC may require refunds for that 2016 to 2020 period?
I think we did have notice of it. I don't think that changes the legal outcome. I mean, the commission has said it was planning to do this and sort of announced it in 569. And we obviously, that's the basis upon which we requested rehearing.
And the precedents that we have that say if there is sufficient notice, then the rule against retroactive rate making doesn't apply. How do you distinguish those precedents?
Well, again, I think this is a situation where we've got a discrete statutory remedy and prohibitions on retroactive rate fixing. So notice, I don't think, cures this. I mean, you can't simply give us notice that you're going to violate the law and then do it, to be candid about it. So that's what we think the commission was doing here.
Okay. So I guess you would distinguish, I'm not an expert, but I've come across a lot of those cases in the Section 205 context. I guess you would say those are different because in the 206 context, the statute specifies the extent of retroactivity.
Precisely, Your Honor. That's what we think the 88 Act clarified and 206A before that. So 206 does act differently than 205 when it comes to the specificity of retroactivity.
Okay, thank you. Unless my colleagues have further questions for you at this time, we'll give you a little time for rebuttal.
Thank you, Your Honor.
Thank you, Mr. Burnett. We'll hear from you on the successive complaints issue.
Yes, good morning, and thank you, Your Honor. May it please the court. Matt Burnett for the petitioning transmission owners. I've informed the deputy that I'd like to reserve 1 minute for rebuttal. As Mr. Jones just stated, in Section 206B of the Federal Power Act, Congress made a clear choice to balance the interests of consumers by affording some refund protection with the interests of utilities by limiting their refund exposure. In this case, complainants in the second complaint case, who were active participants in the first complaint case and who would benefit from any refunds or lower rates resulting therefrom, sought to game their way around this congressional choice by filing a duplicative complaint challenging the same base ROE of the same group of utilities that was already under challenge. By allowing this second complaint to go forward, FERC violated the intent behind Section 206B's clear limitation on refunds and allowed a practice whereby customers could nullify the refund limitations Congress imposed. If Congress intended—
This stacking of complaints leading to a stacking of refund periods, right? It seems very problematic, and you address it in, you say essentially FERC should address this on the front end by not considering the second complaint. But suppose you actually won on what seems to me a very similar issue on the back end, which is FERC saying, sure, we'll consider whatever you want to file and look at updated data or whatever it is. But at the end of the day, we are only going to award a refund in a case where FERC fixes the prospective relief, and that's going to be one and only one case in all but the most unusual circumstances. So assuming we uphold that aspect of FERC's reasoning, do you care about this issue? What extra does this front end framing as opposed to a back end framing get you?
Well, Your Honor, thank you. I think in this case, yes, we did ultimately prevail, and FERC ultimately did, in essence, give us the relief we wanted, which was not a stacking of refund effective dates and refund periods. However, it still would leave open the door for parties in the future to come in with successive complaints, and there's no guarantee that FERC would deal the same way with their complaint. Your question also assumed that
if they fix the rate in the first complaint, and then you have, the second complaint is essentially identical, except it has newer information, and you have whatever case you have that is just a vehicle for avoiding the 15-month limit. I mean, the way their rationale will prevent the stacking, unless there's a weird situation where the new information substantially changes the case. So, somehow the rate that they fix was just and reasonable based on everything they knew through the first half of 2015. And then lo and behold, there's some cataclysmic event. And then when they look at the later information, they find it to be outside the broad zone of reasonableness. I mean, that is not going to happen very often.
Well, I do agree with you, Your Honor, and the way that FERC has indicated that they address return on equity cases specifically is to rely on not necessarily the data that's filed when the complaint is initiated, but the data that's available at the time that the hearing is held. So in that situation, they would be looking at that later data. There's no need to have a second complaint to introduce that later data because it can already be introduced in the original complaint proceeding. So really, even in that scenario, the stacking doesn't really help anything. And it results in administrative waste because now FERC is having to deal with two proceedings, two hearings, two different sets of testimony from all the participants, two different initial decisions by an ALJ or multiple ALJs. And in the normal course would be issuing separate orders. Here, ultimately, they issue one series of orders in Opinion 569. So while, yes, we do think that if the court were to affirm FERC's denial of refunds for the second complaint in this case, our challenge here would essentially be moot for our purposes. But I don't know that I am comfortable going as far as saying that would always be the case, unless FERC continues to adhere to that practice and the court continues to affirm it.
Okay.
Thank you. Let me make sure my colleagues don't have additional questions for you. Mr. Bennett, we'll give you the minute that you asked for rebuttal.
Thank you very much.
Thank you. We'll hear from Commission Counsel now, Ms. Perry.
May it please the court, Lona Perry for the Commission. Starting with the issue of the retroactive relief for the legal error committed by the Commission, I would point out in the first instance that as to the petitioner's argument is essentially that the thereafter observed and enforced in Section 206A precludes the Commission from correcting its legal error in this case. But I would point out that this court has, in several cases, specifically rejected that argument, which is this court's decisions in Electrical District and also in City of Anaheim that said that under 206A, rates can only be prospectively available. In this court's decision in Louisiana Public Service Commission, which is cited in our brief, the court said that FERC's ample authority to remedy its own errors after being reversed in court applies, notwithstanding the prohibition on retroactive rate making. And this was a 206 a complaint that was filed under 206A. Likewise, in Office of Consumer Counsel, which is a complaint filed under Section 5 of the Natural Gas Act, which, as this court knows, is in this respect identical to 206A and is interpreted similarly. The court specifically held that electrical district, which is for the same proposition, is inapplicable to that issue where the commission was correcting its legal error in failing to remedy a violation, and that the issue of whether the rate was fixed or when it was fixed under Section 206, and they cite to the, they compare it to Section 206, and they say the issue of whether the rate was fixed under 206 is irrelevant to the issue of the commission's correction of legal error. And this goes back
to, in this case, you're doing, that principle is well established, but here the commission did a lot more than simply correct an error. I mean, the error in 551, as elucidated by Maine, was not adequately explaining either the unlawfulness of the existing rate or the methodology for determining the new rate. And what you did in 569 was create an entirely new methodology.
Your Honor, I don't believe that that is the case. I will point out that the commission noted in multiple places in the challenged orders that it was addressing the issues remanded in Maine. And the issues remanded in Maine are essentially two issues. One was the commission's use of the single return on equity analysis to govern the unjust and unreasonable finding under the first prong of Section 206. And there was also the commission's use, the commission's selection of a point above the midpoint. Yes, but the important thing about that second issue that you should bear in mind, and if you look at pages 28 and 29 of Maine, this specific problem that Maine had with the commission's rationale there was that the commission decided that the result from its usual discounted cash flow methodology was too low. And therefore it looked at these alternative methodologies, the same methodologies that we're talking about here, in order to find that that result was in fact too low, but did not use those alternative methodologies in order to justify the new rate that it selected. That was the specific criticism in Maine. And what the commission was specifically doing here, as it explained in 569 paragraphs 35 through 37, and in the 2018 briefing order, and what the commission specifically was doing here was improving the explanation as criticized in Maine by using these alternative methodologies to support its actual selection of the just and reasonable rate, as opposed to only using them to undermine what return on equity resulted from the discounted cash flow method.
And that may be a perfectly good method, and it's clearly a good faith response to this court's criticisms. But I mean, you can't say that the proposed method in the briefing order or the two-factor method in 569 or the three-factor method in 569A, you can't say that any of that is compelled by Maine. Those are just new methodologies that FERC created on its own. And there'd be any number of other possibilities that would be just and reasonable as well. So it seems to me you're doing a lot more than just correcting error.
Well, it is certainly the case, Your Honor. I mean, this court frequently remands cases without directing results on remand, and that doesn't change the commission's ability to reach a new result on remand and to give retroactive relief for the time period in between. I mean, a number of these cases that we have talked about, like Office of Consumer Counsel, for example, the court initially found that the commission was correct in finding contracts imprudent under Natural Gas Act Section 5 complaint proceeding, but that the commission erred in not providing a remedy. But what the court did was it remanded that initial finding to the commission to determine an appropriate remedy. But nevertheless, when it came back up on appeal, the court found that the commission had the authority to go back to that original unjust and unreasonable finding and order a retroactive remedy from there. So it wasn't the case that the fact that the court didn't direct them what to do on remand with respect to the remedy prevented them from having the authority to nevertheless make what they ultimately determined to be the remedy retroactive to the very first finding of unjust and unreasonableness.
Sorry, which case?
I'm sorry, Office of Consumer Counsel. It's 826 Fed 2nd 1136.
826
Fed 2nd 1136.
Okay, I don't have that one in my notes. I will look at it. I focused on TNA, Excel, and Tennessee Valley for what it's worth. Maybe I missed one, but it seems to me you're going well beyond what you did and what we allowed in any of those three cases.
Well, that case is cited in our brief, Your Honor, and
I'll look at it.
It does extensively discuss also the Tennessee Valley case that you were talking about earlier. And I mean, in Excel, for example, it was also remanded to the commission to determine what to do with respect to the retroactive. The court did not direct what retroactive remedy was to be provided, but it simply found that the commission had authority to make a retroactive remedy.
The legal error was not suspending the rate filed under 205, and that error could be undone by retroactively suspending the rate. That seems to me very different from what's going on here, where the rate is new the methodology is new, the rate is new in every meaningful sense, and you're retroactively applying it. And the only plausible rationale for that is that you're simply correcting legal error. But as I said, I think you're doing a lot more.
I understand, Your Honor, but I will just point out again, I mean, the commission in the 2018 briefing order, for example, specifically said that it viewed itself as addressing specifically the issues remanded in Maine.
Can I ask the question this way? Suppose that there were no methodological changes. So it didn't introduce the risk premium model anew. There were no methodological changes, but there was still an effort to correct the error that was identified in Maine. So in theory, then the methodology could have stayed the same, but in order to address the error, the rate likely would have changed anyway, right? Even if the methodology stays the same, would we think that the rate would stay the same, or would we think that in order to correct the error, without a methodological change, there would have at least been some adjustment in the rate.
I don't know, Your Honor, if the methodology had stayed exact. I mean, the methodology could not stay exactly the same after Amerimain, because Amerimain specifically held that you can't just look at these alternative methodologies and deem them to give you a basis for a higher return on equity without actually relying on those methodologies. On page 29, the court specifically talks about the range of reasonableness that resulted from each one of those methodologies. And how
one way to think about it is that nothing in Amerimain required the commission to consider the risk premium model. But nothing in Amerimain compelled that. I mean, I understand that the commission thought we have to go back and look at our rate making methodology now, because Amerimain requires that the result in 551 can't be sustained based on the rationale of that opinion, because 531 has been vacated and we use the exact same rationale. And so we got to start afresh. But none of that required the addition, for example, of the risk premium model. It's just that the commission had occasion to reconsider it and decided, in considering it afresh, that this was an appropriate thing to do.
I think the commission saw the Amerimain decision as being a little more specific than that it was directing, if you were going to undertake this kind of analysis, that it was directing, if you were going to use these alternative methodologies, you have to actually use them to calculate the return on equity. I don't believe it saw it as being as broad a question as that, but it didn't. I mean, clearly Amerimain did not direct the use of any of these methodologies on remand. But my question is whether that is essential for the commission to have the basis on which to retroactively correct its legal error and applying an incorrect methodology in the first place.
Can I ask you, shifting gears, can I ask you the same question I put to Mr. Jones, which is, you'll resist the assumption, but just bear with me. Let's suppose that we disagree with you that the 10.02 rate can be sustained, and we agree with the customer's challenges in some measure. What does that do to this issue? Because I'm still not completely following why this issue is still before us if this issue exists because there's a difference between 10.02 and 10.32. And this is the refund to get back to 551 to account for that difference. But once we get rid of 10.02 by hypothesis, then we don't know what is going to happen as a result. So we don't necessarily know that there's even going to be this refund question that comes into play in the remand proceedings.
Well, in the circumstance that you outlined where the commission actually comes back to the 10.32% return on equity, as you said, there wouldn't be any question of refunds. Because
right, so if that's possible, I mean, I know that part of the response is going to be that's hard to conceive that would happen, but it's at least possible. And I guess that's just an illustration of the broader point that once the 10.02 rate by hypothesis were vacated because of we would agree with one of the customer's challenges, then why are we addressing the refund question? Because the refund question seems tethered to the rate. And once the rate's gone, the refund issue, we just don't know what's going to happen with that on remand.
Well, that is right, Your Honor. I mean, we would say, of course, the commission would still take the position that it has the remedial authority to remedy its legal error. And should that be applicable but you
wouldn't have exercised it. I mean, I guess the thing is you would have the position that you would be able to exercise it if you wanted to, but we don't know that you would.
That's right, Your Honor.
I can imagine another scenario where even if it doesn't come back at 10.32, is it possible that sometimes the parties after a remand settle, the FERC and customers and the owners reach an agreement, and if that's the case, then for us to reach out and decide this additional question would almost be like an advisory opinion, putting a a finger on the scale of a possible settlement. The chief is nodding.
Well, that exhibits the advisory possibility. I think that's what my questions are going to, and I appreciate what Judge Walker's asking too. That,
but I also was, do settlements happen?
Certainly, Your Honor, certainly they do. And that very well could happen.
And then what about the advisory opinion point kind of affecting the negotiations during a settlement? Is there a risk that even a certainty that it would, our reaching this question would function in that way?
I don't know that there's any certainty that it would, Your Honor. I mean, it is an exercise of commission discretion. There is, as we were just discussing, no guarantee that the commission would opt to take this step again, even if it had the authority to do so. But it would be resolving the legal issue. Yes.
I mean, I think what the question, go ahead, Judge Walker.
No, please. I was going to switch.
Just to finish the thought and then turn to Judge Walker. I think what that question exhibits is that even if it's not jurisdictionally moot, this question, because in theory it could re-arise, it still would be advisory in some sense, because we don't know that it's going to arise again in this case. We don't know what's going to happen on remand.
Well, it makes the assumption of a remand.
I know you're resisting that, but and of course that's a complete answer. If we don't remand, then we definitely have to address this issue. But I'm just asking you to indulge me on the assumption so I can just understand how the pieces fit together. But I take it that you've already answered that.
Yes.
Just before we move on, indulge me on the assumption that we remand for the sake of argument. This refund issue is not moot in an Article 3 sense, and we have to make a prudential judgment whether or not to address it. The arguments con are the ones the Chief Judge has been laying out. The arguments pro might be you have your position on the extent of your remedial authority. It is what it is. It's teed up before us, and you'd like to know what you can do and what you can't do. Would the commission have a preference on whether we should exercise discretion to talk about the remedy issue in those circumstances?
I think the commission's preference would probably be that you decide the issue, because if there is a remand and this issue does come up again, we face the prospect of there being another appeal presenting the same issue that could have been resolved now. And it could save a great deal of judicial time and everybody else's efforts.
And on your view, the refund clock is still running. So instead of a 4-year thing going back to 2016, we might have a 6-year thing 2 years from now.
That's right, Your Honor.
It might.
Might.
And might not, right.
In your answer, no, sorry, I didn't mean to interrupt you, Ms. Perry.
Oh, no, please go ahead. I was just going to address the other issue briefly if you'd like, but
before that, this relates to Judge Katsas's original question and your answer. Is there any limit that you can give us to what FERC can do that would, so FERC recognizes a legal error of some sort, and FERC corrects it and makes its correction retroactive. When that happens, is there any limit to what FERC can do under the guise of correcting its original error?
I have not seen a case that limits that in any way? Because the entire idea of the case, it goes all the way back to the Supreme Court's decision in Callery, is that what you were trying to do is put the parties in the position they would have been in had the commission not committed the error. And so long as the commission is doing that, I don't believe there is a limitation on the commission's, on what the commission can do to do that, because that's the entire purpose of the doctrine, is to make that so, which should have been so at the time.
But there was no legal entitlement to have this particular methodology used, much less a legal entitlement to have this methodology imposed in September 2016.
I would say what happened was the commission fixed a rate in 2016 that was not the correct rate. And had the correct methodology been applied in 2016, the commission would have reached the correct rate in 2016. And that's why the commission is backdating the refunds to that point.
There is no one correct rate. There are any number of possibilities that would pass muster.
Oh, certainly, Your Honor, but the methodology that was used for that 2016 decision did not pass muster, and it was not sufficient. And so the point is the commission would have used a methodology that would pass muster, that would result in a just and reasonable rate determination, which the court found the 2016 order did not.
Let me ask, I have just one more question before we let you get to the second issue, which is about Tennessee Valley. It's a good case for you. It does allow a refund period outside the confines of the 206 equivalent on the theory that the delay occasioned by a legal error is imposing prejudice, and that's something the commission should eliminate, can and should eliminate. But it's not a theory that once the commission enters a legally erroneous order, that...
Sorry, I missed that. Could you say it again, please?
Sorry, I don't know. iPhone is talking to me for some reason. Sorry about that. It's not a theory that once the commission commits a legal error, that triggers a new refund period that runs as long as it has to run until a later decision in which you get it right. The legal theory in Tennessee Valley was that that second judicially implied refund period runs from the date of the initial legal error, which was a dismissal, until and only until the complaint was reinstated. And FERC once again started engaging with the problem, which makes some sense. There's no right to a decision on a particular day. So even if we extend Tennessee Valley to this case, it seems to me the most that would entitle the customers to is a second refund period running from the date of the initial legal error, which was 551, until maybe Amera, Maine, or maybe no later than when you propose the new method, which is when you're re-engaging in the problem. And that's something like a year. It's not 4 years.
I think, Your Honor, I go back to the error was in fixing the rate. It was fixing the wrong rate. And if the right rate had been fixed, and the right rate was not fixed until 569A, and that's the basis for the time period for the retroactive look back to the error, was We should have fixed the 10.02 rate in 2016, but we didn't because we were applying the wrong methodology. If we applied the right methodology back then, we would have reached the right result, which would have been 10.02. And that's the justification for that time period.
I mean, the error was using an impermissible methodology. And once that is laid bare and you start re-engaging, it seems to me you've cured the prejudice, whatever prejudice comes from the delay attributable to the initial mistake, which was the logic of Tennessee Valley. Anyhow, you've answered my questions. Thanks.
So if you want to briefly address the second issue, you're free to do so, and then we'll ask interveners supporting the commission to present argument.
On the issue of the successive complaints, I will just say the commission, in reading section 206B, found that the 206B requires the commission, upon instituting a proceeding, to establish a refund effective date. And there is nothing in 206B which limits the ability of parties to file new complaints or for the commission to establish new proceedings or new refund effective dates. The limitation, the 15-month limitation upon the ability to order refunds happens only at the conclusion of any proceeding. And as was discussed earlier, this case is an example of how just because there are successive complaints doesn't mean that there are going to be successive refunds granted. And the commission can only grant refunds in the second proceeding if it finds that the rate from the first proceeding is unjust and unreasonable, or if the first complaint is denied and the rate is not found unjust and unreasonable until the second complaint proceeding. And then the commission could order refunds then as well. But the commission found that there was no restriction to the ability to file new proceedings in the first place, but that the issue about refunds would be addressed at the end of the proceeding.
Is there any practical difference between what you did, which is solving the stacking problem on the back end through your interpretation of 216 versus solving it on the front end by saying, look, you can't file a complaint that is essentially duplicative. And if you want to introduce updated information that's relevant to a pending case, the normal thing you do is you update the information in the pending case. You don't file a different case. You don't file a second complaint and say, this case is different because I have additional information.
Well, in the case of a return on equity, it is all about the current market, how the conditions are in the current market, and which, as the commission has said, it's very volatile, changes. And so I would say it makes a difference because of what I was just discussing. For example, if these two complaints were filed and the commission had found in the first complaint proceeding that 12.38%, the existing rate, was just and reasonable and had allowed it to continue, it could have then granted the second complaint on the 12.38% rate and found it unjust and unreasonable and granted refunds. And if you prevented the filing of the second complaint, then they would have been denied that relief, even though it was justified under the statute, which is different than at the end of the day determining whether or not there is in fact a basis for refunds.
What does the second complaint add other than a vehicle through which to provide the commission with more recent information? And why wouldn't you just do that in the first complaint, in the first proceeding?
Well, because the refund periods for the complaints and the effective dates of the prospective rate going forward are different for the two different proceedings. And so you couldn't get to the same place. And the commission uses the most recent information about the market at the conclusion during the hearing in any particular case. And so all of the timing differences would make a difference in when the rate was effective, when the refund period was, and what the rate was based on what the current market conditions were.
Let me make sure my colleagues don't have additional questions for you, Ms. Perry, on these issues. Thank you. Thank you. We'll hear from Mr. Fontham now.
Thank you, Your Honor. My name is Mike Fontham. I represent the Louisiana Commission and the intervener, customer side interveners. I first want to jump into this issue of the effective date because this argument, I believe, is proceeding on an incorrect premise. Thereafter does not modify when the FERC sets a new rate. Thereafter modifies the finding of illegality. And this court has held that. Statute says, and this is actually in the Office of Consumers Counsel case, the counsel cited earlier, 826 Fed 2nd, 1136. It's on page 1138 or 1138. They quote the Natural Gas Act, exact same language in the Natural Gas Act, which says whenever is temporal, it modifies something. Whenever the commission shall find that any practice, rate, etc., is unjust, unreasonable, unduly discriminatory, and so on, it shall set the rate to be thereafter in force. Thereafter was intended to mean, you can't keep an unjust and unreasonable rate going. In that case, one of the sides gave the interpretation of the statute as follows. The prospective nature of Section 5 relief means simply that the commission has no power to order reparation for illegal rates or practices that extend prior to the date of the commission's finding of illegality. And then the court said, we agree with this interpretation of the statutory language. And think about the effect here. What the owners are asking you to do is to put the 12.38% rate back in force, all the way since Opinion 551. And that has been determined unjust, unreasonable, and unlawful. And this, there is nothing in the Federal Power Act, the Regulatory Fairness Act, to suggest that Congress ever intended that an unlawful rate should continue after the finding of illegality. The finding of unlawfulness is not on appeal here. It's done. It didn't change from 551 to 569 to 569A. The rates are unlawful, and they want to put them back in effect until FERC gets around to setting a new rate. Also, there are two Louisiana Public Service Commission cases that are right on point on this. In both, one was in 2007, Judge Ginsburg wrote it, and the other was a per curiam decision in the famous FERC rough equalization case. And both of those cases said, once FERC finds a rate unlawful, it cannot delay a remedy. And the court required FERC to go back to the time it found the rates unlawful and provide a remedy from the time they found the rates unlawful. They hadn't fixed a rate yet, or not until 2000. It was 2005. FERC didn't get around to accepting a rate until 2007. Or 2007. Court said, you can't do that. It's the finding of illegality that is the important thing, not when you fix a rate. You have to fix a rate, make it start when you found the prior rate illegal. I might also mention that the notice decisions, are not limited to court decisions, and they're not limited to Section 205. That, the first one, well, actually, the Office of Consumers Counsel case was also went to the issue of legal error. And the court has held in many cases that any number of things, filing a complaint, certainly a petition for rehearing, suggests that everybody should expect that something might change. So they were on notice. Now, I do want to address this second issue of the second complaint, because the court should realize this. The owners are asking you to overturn 3 decades plus of precedent. As soon as the Regulatory Fairness Act was passed, the issue came up, stacking complaints and stacking refunds. And in case after case after case, FERC held, yes, you can have a second complaint because the Federal Power Act doesn't say you can't, and the intent was to help consumers and to have symmetry with 205. And that never got judicially reviewed because no utility has ever appealed that before. And if you look at what FERC said in the hearing order on the second complaint, it explained exactly how these things work and how you would calculate the refund for the first period and the refund for the second period based on different data for each period. And Judge Katsas brought up the issue of, stacked complaints. I mean, if you refer to it like that, sure. But think about this. We're in MISO. MISO is a huge area. My clients in Louisiana, we have a separate transmission pricing zone from Arkansas. It's in MISO. Okay, so let's say Arkansas files a complaint and they, diddle around with it. Settlement goes on for 1.5 years, and then they start moving forward with the complaint, but they don't push it. The owners are saying, and let's say that economic conditions totally changed, like they did in 2008.
Mr. Fontham,
The owners are saying,
I think we have your argument on this point. I don't want to cut you off, but if you can, your time's expired. So if you can bring it to a conclusion, we'd appreciate it.
well, I'm sorry, Your Honor.
No need to apologize. No need to apologize and finish the point.
The thing is, Congress never intended that nobody else could ever file a complaint until the first complaint was ended. That's would be a ridiculous interpretation. And Congress didn't intend either that there can't be different refunds based on different rates of return. Okay. That's, in fact, if I could just add one more thing, Your Honor.
Okay.
Would it be permissible?
Yes.
Before the Regulatory Fairness Act, all these rates are formula rates. That means the rates change constantly. All the utilities have to do is put new inputs in. Before the Regulatory Fairness Act, FERC was starting to attach requirements for equity cost reopeners in those rates because it was fixed. The only thing besides depreciation that were fixed in these rates. So it's not just unreasonable to have these formula rates without equity reopeners.
Okay.
Then they passed the RFA. I was in a case where
thank you, counsel. I think we understand. I think we appreciate that point as well, and we appreciate your argument. Thank you.
Okay, thank you, Ron.
Unless my colleagues have questions for you.
No.
Thank you, Mr. Fontham. Mr. Jones, we'll give you the 3 minutes you asked for rebuttal.
Thank you, Your Honor. A quick note about Consumers Counsel, if I could, before I move on to the Chief Judge's concern about an advisory opinion. Consumer Counsel doesn't apply here. It predates the Regulatory Fairness Act. It wasn't even a numerical rate case. It dealt with the timing of removing take-or-pay clauses that were deemed illegal under the Natural Gas Policy Act. So it's a very loose application, if at all, to this case. I'd like to respond to Mr. Fontham, which will then sort of dovetail into the Chief Judge's concern about what Congress intended here about the 12.38% and once a rate has been deemed at some point unjust and unreasonable. Congress in the 88 Regulatory Fairness Act, this is exactly the construct that Congress put in place. And Mr. Fontham seems to be arguing that the Regulatory Fairness Act wasn't fair enough. And I take that point perhaps, but the law is what it is. And what that requires, back to the Chief Judge's question, the reason we have to have this case decided and this issue decided is because there are two separate things going on here. And my previous answer probably didn't do a good enough job of clarifying the two. The refunds, because we were charging the rate that now FERC has self-vacated, the 1032, the refunds were of a much smaller band. But if we're right on the statute that you can only fix a rate to be prospectively observed, then and this is illustrated in footnote 5 of our brief, we give a sort of a garden variety example of how this should work. The pre-existing rate comes back to life during the interim. And so we have to, as long as FERC believes that these interim orders, the 1032 has any legal effect at all, then no matter what happens to the rate on remand, we have to have an answer to this question, because FERC's going to try to backdate some result, and it's going to try to deny the proper workings of 206A and 206B together.
Well, we don't know what FERC's going to do, but when you say the pre-existing rate, which pre-existing rate do you have in mind?
That's the 12.38, right? That Mr.
Yeah, I think that's right, that would be the rate under the hypothetical scenario that would come back into being.
That would be so, right. So, I mean, in theory, even if, back to Your Honor's hypothetical, on remand, if you decided 10.02 was, I'm not sure how you get there, but even on remand, if you got to 12.38, the commission's been asking us to charge the 1032, and then we had to do refunds to 1002, both of which at that point would have been vacated by the commission.
But you'd have to recalculate the refunds anyway, right? Because the commission would have to come up with some replacement rate. So then there would have to be.
No matter what happens here, Your Honor, there's going to be a resettlement of some sort.
Right.
But it is critical to proceed, and to Judge Walker's question about a settlement. If we don't have legal certainty on this question about the commission's ability to do retroactive relief in violation of the 88 Fairness Act, tough to see how that could happen.
Can I ask, could you just give me your answer to Mr. Fontham's core statutory argument that 206A has an express temporal scope, and it requires prospectivity from the date when the pre-existing rate was declared unjust, not prospectivity from when FERC fixes the replacement rate?
Briefly, Your Honor, on that, not only FERC doesn't even make that argument. I think
why is it wrong?
I
hadn't thought of it, but I'm just reading the text.
Understood.
I see how he reads it.
Yeah, I think that turns the Regulatory Fairness Act on its head and the entire 206 structure on its head if the commission can merely declare a rate unreasonable and then at that point go off, take as however long as it wants to find the new rate and then backdate it. Again, if that were true, then the Regulatory Fairness Act wouldn't have been necessary. The 15-month refund protection and everything else would have been completely unnecessary. So I just don't think that statutory framework finds any support.
Well, no, that's not right. I mean, they have to do a lot of work to find the existing rate unjust. So the 15 months from when the complaint is filed would do a lot of work, even assuming that the prospectivity clock starts to run when they say the existing rate is unjust.
Right. And I guess, so in that situation, the commission would have made an initial determination that the existing rate is unjust and unreasonable. And then later on found that the rate, it determined the rate, but it wouldn't have fixed the same by order. I don't think Mr. Fontham completed the sentence. There, it must shall determine the just and reasonable rate to be thereafter observed and enforced and shall fix the same by order. So again, read in context, it has to be prospective only. And that again, this is a 206A construct. And there are all the cases that we cited about 206A and Section 5 of the Power Act that even predate the 88 Fairness Act don't support that statutory interpretation. This has long been held that a rate fixing has prospective relief only, and that in this court in Electrical District in Anaheim among them.
Yeah, the question is prospective relative to what? And just reading that sentence as a matter of pure grammar, I can see an argument that thereafter observed modifies what comes before it, not and shall fix the same by order, but
thank you, Chief Judge. Appreciate it.
Thank you, Mr. Jones. Unless my colleagues have further questions for you. Mr. Burnett, you have 1 minute for your rebuttal.
Yes, thank you, Your Honor. And I'd like to start with Ms. Perry's arguments. She seemed to suggest that FERC was bound to consider the second complaint and establish a refund effective date because the statute says when FERC opens a proceeding, they're required to establish a refund effective date. Well, that's only true if FERC actually opens a proceeding. On page 48 of our brief, we cited cases where FERC has either dismissed a complaint as facially deficient or has denied a complaint on the initial papers without actually setting a hearing. So the idea that FERC had to entertain this complaint because it had to establish a refund effective date is belied by FERC's own precedent. On her second issue of, well, what happens if market conditions change dramatically after the first complaint is filed? Parties need to have a second opportunity. Well, that's already covered by the fact that FERC uses the latest data in the record. I believe Ms. Perry is conflating two different issues. One is the establishment of a refund effective date, which is tied to the initiation of the proceeding, and the data that's used to make the ultimate determination, which is data that comes into the record much later. So you don't need to have a second complaint to take account for that data. Now, quickly, if I may, just turning to Mr. Fontham's arguments, he says that what we're asking for is the court to overturn 3 decades of precedent. But he also admits, and FERC admits, that all of that precedent is FERC precedent. We were not able to find any precedent of this court that would necessarily affirm the practice of allowing successive complaints to extend the refund effective date and refund periods. Mr. Fontam also suggested that our argument is that once a complaint is filed, nobody can ever file a complaint again. And that's just not true. What we're contesting here is the filing of, as Judge Katsas aptly put it, an identical complaint for the purpose of merely extending the refund eligibility on the same rate. So if a party files a complaint to challenge either some other aspect of the utilities rate or to seek an additional lower rate as a prospective matter, that's not what we're challenging here. And so I think that that's an overstatement of our argument.
Okay.
Unless the court has any other questions for me, I appreciate your time.
Thank you, Mr. Burnett. That'll conclude our arguments on the transmission party's challenges. Why don't we turn to the customers' challenges? Mr. Pomper.
Hey, please the court. David Pomper for customers. FERC rightly framed its task as using financial models to keep base returns at cost. But FERC adopted unreasoned models that exaggerate costs and a so-called presumption that keeps returns even higher. Each 1% of extra return here exceeds $100 million a year. Heartland factories started these cases because they need fair cost-based rates to compete in global markets. Now, yes, FERC also owes fairness to the owner's global shareholders. But when FERC pins fairness to model estimated cost, then jiggers those models until they exceed 10% and presumes customers should pay even more, fairness demands explanation. We briefed many explanatory misses. I'll highlight 3 regarding models and 1 regarding burden. FERC's capital method has diversified stocks returning nearly 12% per year forever by always growing much faster than the economy or any independent estimate. In contrast, FERC's sister agency, the FCC, uses 8.71%, JP Morgan 6.5%. FERC's exaggeration contradicts its own findings that, quote, over the long term, companies cannot maintain their short-term growth rates, unquote, and that they converge toward, quote, the growth rate of the overall economy. Now, FERC excuses that contradiction by speculating that the S&P 500 index can grow immoderately because its roster revolves. But the index hasn't grown that way, and there's no evidence that it will. FERC used 370 specific stocks, not that slowly evolving index, and FERC refused to measure utilities' risk betas against that index. And even if FERC's irrelevant and unsupported claim were true, that would mean that FERC wrongly used the growth of selected winners, not the market portfolio the method demands. Now, over a baseball season, batting averages converge toward 250 or so. FERC's like, well, that's true for every batter, but the league will average 400 because we're Yankees fans and they can trade with the Royals. It's just a non sequitur. Method error 2 is FERC's adoption of a risk premium variant that nobody else uses. Not investors, not other regulators. Opinion 569 detailed its flaws, as did later dissents. It's intensely circular, perpetuating past FERC returns by ignoring the evidence and published findings that equity returns follow bond yields down. It mainly perpetuates settlements that trade off other issues and lock in the error that MRO reversed. 569A flipped to ignoring this method's flaws, not curing them, just to blend it in with other methods. Method error 3 concerns FERC's model results distillation. Under this court's 2005 Kentucky and 2013 Southern California precedents and the statistical principles they cite, FERC normally uses medians. But FERC may use midpoints in the unusual situation of setting a region-wide return when the top and bottom results are for the region's owners themselves, making it reasonable to emphasize their extremes. But here, FERC never examined whether the broad national proxy group's extremes represent this region's owner extremes. Instead, FERC erroneously viewed the 2005 precedent as dictating midpoints in this new context. In these and other ways, FERC exaggerated what investors need. Worse, for its 206 prong 1 evaluation of existing returns, FERC adopted a rule favoring yet more. FERC now keeps returns until they become grossly excessive, reaching the result's upper third. For this region, that excess means roughly $100 million a year. Now, FERC's so-called presumption really means disregarding evidence. Complainants have always faced a presumption of reasonableness, meaning they must prove unreasonableness. But until now, they could carry that burden using the central result of FERC's own equity cost models. FERC's new rule treats that central evidence as no evidence at all that a return should fall. Now contrast that to when owners seek rate hikes. In that situation, FERC's adopted models alone suffice to prove their central result reasonable. Only when customers seek rate cuts does FERC discredit its own models and demand other evidence. Under the court's 2014 First Energy decision, customer and owner proof burdens should have remained symmetrical. FERC then made customers' proof burden impossible by demanding that they overcome a return not known before the record closed. It made customers fire blanks at a moving target. Now, FERC tries to pin its new role on this court, but the court doesn't defer to agency interpretations of its own opinions, and dissents below dispel FERC's. Emmer did not conflate potentially reasonable with presumptively reasonable, nor did it reverse the 1942 Supreme Court opinion it cited and other opinions it cited, under which FERC may judge unreasonable any return exceeding cost. Emmer merely demanded that FERC explain such judgment. Here, FERC's only explanation for retaining returns approaching the upper third was, well, the upper sixth would have been even higher. But comparing two wrongs doesn't make one of them right. And less unreasonable does not mean reasonable. On all these issues, FERC falls back on agency expertise and discretion. But FERC said it was exercising its discretion by relying on model estimated cost. Under EMERA, the court examines whether FERC's method employed in implementing that policy was rational, and here it wasn't. Now, let me pause and invite questions, but I think that lays out the key points.
Ask my colleagues if they have any questions for you, Mr. Pomper. I think you have reserved some time for rebuttal. We'll give you the time for rebuttal after hearing from FERC's counsel. Mr. Wolf, we'll hear from you on the refund question regarding the second complaint.
Thank you, Your Honor, and may it please the court, Eric Wolf for customers. There's been some discussion about whether the refund issues are something that you should address. You should. And the reason you should is that FERC made a fairly clear error of statutory interpretation because they said that the denial of the refunds was, in their words, dictated by the language of the statute. Basically, Chevron step 1 made them do it. The statute made them do it the way they did it. That is not defensible. That should be corrected. And I'll just walk through how what they did really does not fit 206A or 206B. And we think it's clear that refunds can be available. At the very least, it's ambiguous and it has to go back to them under PRIL, and they have to exercise their discretion. And on a number of these things that have been discussed, I mean, they have policy choices to make, and they can't claim that the statute dictates what they did. So on 206A, what the statute requires is that you look to the rate that was charged, observed, charged, or collected, or demanded. And that's the money that was paid. That's the rate that was actually charged. But they didn't do that. They said, well, we'll look to the rate that we just set in the first complaint. So right there, they're going beyond the statutory language of 206A. They can't legitimately claim that the statute dictated that choice, although that is what they claim. Now, if you find that gap, and here, everybody, it's not being disputed that on the second complaint, there was an unjust and unreasonable rate that was charged. And so if we follow 206A, it says if that's the circumstance, then the commission shall determine the just and reasonable rate. There's no discretion there. They have to do it. And then they shall fix the same by order. Now, I suppose it could be that it's the same rate that they come up with in the first complaint, but just following the statutory language, you have to do different things than what they did. So what they did was look at a rate that was not the rate that was charged, and then they dismissed the complaint. The statute requires that they look at the rate that was charged, and if it's unreasonable, which it was here, then they shall determine the just and reasonable rate. They shall fix the same by order. They didn't have any discretion to do what they did. Then we go to B. You don't look at, hypothetically what people would have paid. You look at the amounts paid, and amounts paid. That's plain enough. That's the money that was paid. Here, that money was paid in excess of a just and reasonable rate, and so then you could possibly have a refund. And what's curious about how FERC resolved all this, and I must confess I'm sort of baffled by it, is that the refunds, they have discretion on refunds. They may, like the statute's filled with shalls, but on the refunds, it says they may order a refund. And so they did not need to contort the statute the way they did if, for policy reasons, they want to say that refunds on the second complaint are not appropriate. But what they do have to do then is give us those reasons, explain them, and then it can be reviewed under arbitrary and capricious review.
What is left of the 15-month limit for 206 refunds if a customer can file sequential complaints that are identical except to the extent that the later complaint offers more recent information that becomes available with the passage of time?
I think, there's a formalism to saying, there's the first complaint and the second complaint, and they each get their own refund period. And the way you frame it is the way our opponents frame it, which is, it effectively extends the refund period. And that's understandable that they frame it that way, but like formalistically, just following the statute, nothing prevents that. And you've posited, well, you could stop it on the front end or you could stop it on the back end. And I suppose you can. I mean, they could have a heightened threshold under 206A, and Amerimain, emphasized that there are different burdens, and they have to do, unjust and unreasonable on the front end. They could address it there. Again, issues of policy that they are free to address, and you can get to it on the back end. They have discretion. I don't think reading into the statute, adding to the statute, something that says you can't bring a successive complaint, and really you'd have to even construct some kind of window, because we know you can bring, you have to be able to bring successive complaints, right? Because like a year or 2 or 3 could go by. So it's really, you know, we don't want them too successive. We don't want them too close. I mean, now you're just rewriting the statute. So they may have, in their view, a policy problem that they want to solve. To say that the way they solved it by saying no refunds was dictated by the language, it is not. They need to give their policy reasons and make their choice, and then that gets reviewed by you all under arbitrary capricious review. But they've made a mess of the statutory language, and it is not clear, and it does not dictate what they did. And I don't know if I've really answered your question, Judge Katsas, but I mean, it's a formal distinction. I mean, it's a literalism that there's nothing that prevents it. But you know, that's this whole little scheme here is kind of outside of what Congress anticipated in lots of ways. I mean, Congress thought that FERC would act as speedily as possible, and you know, maybe all this will be done in 15 months or 2 years. And so to say, oh, we're, you know, cut off at 15 months, no matter how long it goes, I don't think there's any support for saying, well, yeah, that's what Congress would have wanted there too.
What about fixing this on the front end by reference to some sort of, I don't know, general background, res judicata principles? I mean, ordinary rules, you bring a claim seeking prospective relief, and you have whatever evidence you have, and time goes by as the case is pending. No one in their right mind would think that when you get newly developed evidence in the pending case, what you do is file a second complaint seeking exactly the same relief and saying, oh no, this case is different because I have new evidence, and that you could litigate both of those cases to judgment. I mean, you would just litigate the first case and put in the new evidence.
Or you would consolidate them or something
Right,
like
yeah.
that.
Yeah, exactly.
Yeah, I mean that's, I mean, they, you know, here they address them together. I mean, if you want to get very literal, under B, like literally, they entered an order that fixed a rate in this proceeding, and so a refund would be available. I mean, that's literally what they did because they addressed it together. I think it's going to be, I don't want to speak too broadly here, just to be perfectly candid. I mean, I do not make my living doing the trial type for proceedings that some of my friends do. But they clearly have a fair amount of discretion to set their own proceedings, to work with the burden of proof, and to try to solve this problem to the extent there even is a problem of, you know, what you call duplicative complaints. Now, I can tell you that talking with the customers, they pointed out that there's a lot of investment that goes into bringing one of these, and you know, the kinds of economic analysis that they have. This requires experts. You have to do a discounted cash flow analysis. Now you might have to do risk premium, maybe other methods. You have to come up with proxy companies. If you try to seek a new rate under 206A and it doesn't come packaged with that kind of evidence, you know, you're not likely to get very far. So it is not the case that you can just sort of casually file one of these things and hope to, you know, get in there for a refund. A lot more goes into it. But if they think that is a problem, they have discretion to address that problem.
That's just one question, which is, I thought I heard you say something contrary to this, but I may have misunderstood. Isn't the very premise of the 15-month period that Congress contemplated that the commission would take longer than that to issue decisions?
I think, and some of this is going into some legislative history, but they thought it might take around 2 years, it's my understanding. So it is definitely there to provide certainty. But if you look at the full text of 206B, you know, they put in there that, you know, they're supposed to act as speedily as possible. And then if no decision is rendered by the conclusion of a 180-day period, then they have to give reasons why they failed to reach a decision. there's nothing in there that suggests that Congress would have been fine having this run for 4, 5, 6 years or more, and everything's cut off at 15 months. So if they're thinking, well, it could take 15 months, maybe it takes 2 years, 3 years, that perhaps, but when it's taking so much longer, I don't think the folks on the other side can say, well, this is what Congress would have wanted. They would have wanted it all cut off at 15 months, no matter how long it takes. I just don't think there's any evidence that Congress would support that, nor that that's a good idea. Because as Mr. Pomper said, this is hundreds of millions of dollars. And, the purpose of 206A and B is to protect consumers, which is, as he said, they're big industrial customers who are trying to stay globally competitive. So.
And make sure my colleagues don't have additional questions for you, Mr. Wolf.
Set.
Thank you, Mr. Wolf. We'll hear again from Ms. Perry now on this set of issues.
Thank you, Your Honor. I believe I will start with the issue of the refunds for beginners. In the first place, the Commission interpreted the language of 206B. The Commission did not find that the language was unambiguous. Rather, in paragraph 568 of Order 569, which is the Joint Appendix 719, the Commission looked at the language of the statute and found we interpret this language to mean the refunds may be ordered in a complaint proceeding only when the Commission grants prospective relief. Because having not ordered a new just and reasonable rate to be thereafter observed, there are no amounts paid in excess of that rate that the Commission could order to be refunded. And the Commission further went on in paragraph 569 to point out that this interpretation was supported by the 15-month limitation on refunds, which were clearly intended to limit the refund exposure of public utilities. And this interpretation would prevent having multiple refund periods tied to the same unjust and unreasonable finding.
Can I ask you a question on the arguments that the customers have raised, not on the refund questions, but on the challenges to the methodology giving rise to the rate that's being challenged?
Certainly.
That's on the addition of the risk premium model. So you have a scenario here in which the Commission itself explained why the risk premium model didn't make sense to include, and then a subsequent iteration in which the Commission reconsidered that and thought that it would consider the risk premium model. And at least one of the predicates was for the initial determination that it would not be used was that customers don't rely on it, was that investors just don't rely on it. And that seems true. And I didn't see anything in the Commission's subsequent decision that called that into question.
What the Commission ultimately determined was, well, let me state first that as Mr. Roger Morin said in his textbook, that this methodology examining the risk premium that's applied in return on equities versus the Treasury bond yield is an accepted method of doing a risk premium model. And that's at 569, paragraph 305. With respect to the argument that investors don't use this model, what the Commission ultimately concluded was that investors expect risk premiums above bonds, and that this model, as evidenced by Mr. Morin's textbook, is a method, an accepted method of estimating that risk premium. The investors do observe the return on equities and how they affect earnings. But so the Commission felt that because of those reasons, this risk premium model was on balance helpful to the analysis, because the Commission ultimately determined that the defects, which it acknowledged and had discussed at some length, of the model didn't outweigh the benefits of having model diversity, having the additional model averaged in with the other models, and the decreased volatility that comes from having this particular model averaged in with the other models.
In 569, the commission had a fairly robust criticism of this model, risk premium model, on the ground that I think it was you would expect interest rates to be inversely correlated to stock prices, and that's not what this produces. And you went on at some length about that. And then you changed course on rehearing, and without much explanation, you just said, well, we're no longer persuaded by that. So why is that sufficient explanation to change course like that?
I think the commission's basic explanation on that, with the talking about the regression analyses that were trying to show a lack of relationship between market changes and the changes in the return on equity and the risk premium implied from that. And the commission ultimately concluded that ultimately rejected the idea that there was not market influence on the risk premiums that were being awarded. A large number of them are settlements, and the commission found in 569B at paragraph 119 at JA 1081, the commission found that there were sophisticated parties engaging in complex negotiations and trial staff, all of whom are relying on market data to inform their positions. And so the commission ultimately rejected the notion that there was no market tie between the risk premium results and the market conditions.
The only other one I had, there's a lot of detail here, and it tends to be very technical, but could you address the argument about on beta, about the mismatch between New York Stock Exchange data and S&P 500 data? So as I understand it, and correct me if I'm wrong, but when you calculate the market risk premium, you use S&P, and when you calculate the betas from value line, you use the New York Stock Exchange as the baseline for comparison. And as to each half of that, you have what seem to be fairly plausible arguments. But on the other hand, you are mixing and matching, and the selection of each one in the particular context tends to produce a higher rate of return. So why shouldn't that at least raise an eyebrow?
Well, for starters, Your Honor, this is an issue that goes back to the Supreme Court's decision in Prometheus Radio that we talked about in our brief, which essentially, where the Supreme Court essentially recognized that agencies rarely have perfect empirical or statistical data to deal with, and what they need to do is to make the best decision they can based on the record before them. In the case of the value line betas and the S&P risk premiums, the commission acknowledged that it was in imperfect correspondence, but the commission found that there was substantial value in using the value line adjusted betas, and that investors substantially relied on those betas. And that there wasn't an equivalent there wasn't equivalent information in the record about S&P betas, that adjusted betas, that the commission could use to make that calculation. And so I would just say in that regard, the Louisiana Public Service Commission has pointed on several occasions, making the argument that they put in evidence of adjusted betas for the S&P 500. That is at JA 362. And I would point out to you that those betas are from 2019. And so the commission's orders are quite clear that financial evidence had to be from the relevant time period, which would be during 2015. And so the commission did not have in the record the adjusted betas available for the S&P 500. And so the commission made the judgment on the record that it valued having the adjusted betas in the calculation, and that no one had made a showing that using the value line New York Stock Exchange adjusted betas with the S&P 500 risk premium analysis would result in an unadjusted and reasonable rate. Is
that timing discrepancy the same explanation for why there was that recent order by the commission in Constellation Mystics or Mystics Constellation? I can't remember which one is which direction it goes, but where instead of the value line NYSE adjusted betas, there was Bloomberg, which were pegged to the S&P 500. So there was an alternative there.
There was an alternative there because the trial staff in that case came up with the methodology, their expert came up with the methodology for adjusting the S&P 500 betas. And they put into the record the methodology and the adjusted betas for the test period. Mm-hmm. And so the commission decided that there was substantial evidence that supported the methodology for adjusting the betas, and that they had the actual adjusted betas in the record for that test period. And under those circumstances, the commission decided that it was better to use the matching betas when it had the information available to it. And that's the issue here, is that the information was just not available to the commission, and it made a choice to use the imperfect match, finding that that was better than the alternative.
Yeah.
Ms. Perry, FERC's model with the three different types of methods is new. If it's the right model, what does that say about all of the existing rates outside of the MISO territory? Are they also based on the old methodology where I think it was mainly discounted cash flow? And I guess I'm just wondering, like, how much of what happened here affects the rest of the country?
Well, it will certainly affect new calculations of returns on equity, particularly in this kind of situation where you're dealing with a region-wide return on equity. It would certainly affect ones going forward. And parties would be free to file complaints based on existing returns on equity if they felt they were not just and reasonable, but it would not have any immediate effect on any of the improved returns.
And maybe this is too far astray from the merits of this case, which are complex enough. But what are the chances that all of the rates outside of MISO, or a lot of the rates outside of MISO, are unjust and unreasonable from a 206B perspective because they're based on the old methodology?
I don't know the answer to that, Your Honor. It's not the case, though, that there have never been changes in the methodology. I mean, one of the issues that was not put up for argument today, but is the change that the commission made in its discounted cash flow methodology. And so the discounted cash flow methodology itself changes. And so it's not the case that everything had been static up until this point, and there were suddenly changes. There have been variations in methodology throughout.
Okay, I appreciate that. I have one hypothetical that probably ties more to the first discussion we were all having than this current discussion, but the discussion of the risk premium model made me think of it. So imagine a 206B complaint is brought in 2017, and in 2020, an order goes out using the methodology that you used here, a combination of the discounted cash flow, the capital asset pricing, and the risk premium model. And that gets challenged. And we say we think the risk premium model was not sufficiently explained. And so we remand. And then FERC says, well, while we're on remand, we're going to just completely redo the whole model. We're going to use totally different things. We're not going to do capital asset pricing. We're going to do some fourth or fifth or sixth. If it does that, can it order refunds going back to the 2020 order that did, like this order, discounted cash flow, capital asset pricing, and risk premium model, and whose only flaw was that the risk premium model was not sufficiently explained?
This goes back again, Your Honor, to the Commission's ability to correct its legal errors, and to the extent its application of methodology was a legal error, it should have the ability to place parties in the position they would have been absent that error.
But in my hypothetical, the only legal error that this court is declaring is that the risk premium model is insufficiently explained. And yet then on remand, FERC not only fixes that error, but it completely redoes all of the other aspects of its model. And I think you're saying in that situation, FERC could order a refund going back to 2020. Is that right?
Because the legal error ultimately is fixing a rate that is not shown to be just and reasonable. And when the Commission fixes the just and reasonable rate that should have been fixed had it applied a correct methodology at the time, then that would be correction of legal error. And the Commission, it should be within the Commission's remedial discretion to fix that.
Okay, all right, thanks.
Which is the same theory they're asserting here for 2016.
Okay. Unless you have a response to that, Ms. Perry, let me make sure that my colleagues don't have additional questions for you.
Is that right, Ms. Perry, that in my hypothetical, the error is of a similar magnitude to the error that FERC was correcting with its 2016 error?
I don't agree, Your Honor, that it's of a similar magnitude in the sense of, again, I would go back to the Commission felt that it was specifically addressing the criticisms in Amerimain with its treatment of these other methodologies, of its alternative methodologies in these orders. It's not that it went out and found entirely new mechanisms of calculating the return on equity. It viewed itself as directly addressing the concerns that Amerimain had expressed. So I wouldn't say this is of the same magnitude as your hypothetical.
But if we were to set aside the rates here because the risk premium model was insufficiently explained, you would have a range of options on remand, ranging from trying to shore up that explanation and maintaining the exact approach you're using to a complete overhaul.
Yes, Your Honor, but that is common in remands, that the court finds error and remands the case without directing the Commission to come up with a specific result on remand.
And the refunding is common?
It is, but it tends to suggest that what happens on remand might or might not be fairly characterized as simply correcting legal error. I'm sorry, I interrupted you, Judge Walker.
No, that's great. I'm curious to hear Ms. Perry's response to that. And Ms. Perry, I think I'm asking you, even if it doesn't sound like it, somewhat friendly questions but can you answer Judge Katsas's? I know what FERC's answer is to that.
I apologize, but I have entirely forgot. Could you ask your question again, please?
That's you, Judge Katsas.
What's that?
I think.
I'm sorry, Judge Katsas, I entirely forgot your question in between the.
I was just making the point that you have a lot of, if hypothetically we were to set aside this order on the ground that the risk premium component was inadequately explained, you would have a range of options. You're absolutely right. You could pick on remand whether you try to do something very narrow on response or in response, or try to do something very aggressive. And the one might look like merely correcting legal error. If you were to redesign, that would look to me like you're doing something more than that. I mean, we've talked about
but that would affect whether you can do a refund going back or
yes,
not. I think.
Yeah.
So, I mean, I think it's, Ms. Perry, I think it's a really good opportunity for you and FERC to explain why what happened in this case with the fixing of the 2016 order was not fixing one small legal error and aggressively doing a bunch of other stuff while you have the opportunity, but was instead fixing the 2016 legal error, nothing more, nothing less, which makes a refund sound a lot more reasonable, especially in light of our precedents along those lines. So can you say why what you did in 2016 was nothing more, nothing less than correcting legal error?
Again, Your Honor, this is exactly what the commission said, that its methodology was, the methodology being implied here was specifically in response to Amir Main. The 2018 briefing order and paragraphs 10 and paragraph 16, the commission said, we are proposing this specifically in response to the issues remanded in Amir Main.
So can I just say
reliance on the four models specifically?
It sounds like then the limiting principle. So I think the way this lays out in my mind, at least, and I think it's commensurate with the way that my colleagues are thinking about it, is if you think that there's some distinction between correcting a legal error and then doing other things that go beyond what you need to do to correct the legal error, then how do you draw that line? And it sounds to me that what you're saying is, as long as the commission in its recitation of what it's doing tethers it to the correction of the legal error and says, this is all part and parcel of responding to the legal error that's been identified to us, then we defer to that. But then on some of the hypotheticals you've gotten from Judge Walker and Judge Katsas, I mean, you could imagine a commission that would say, we're going to correct the legal error, and then we're just going to tell you we're going to go on doing a bunch of other stuff that has nothing to do with the legal error, but we're going to do it anyways because we now have an occasion to revisit what we did the first time. That, it sounds like, even you would say that falls outside the 309 authority. But then it sounds like what you're saying is what always falls within the 309 authority is anytime the commission professes to be tethering its remedy to the legal error that was identified and that caused the commission to act.
And yes, right. And it depends on if you're defining what the legal error was. Here, the legal error was the applying incorrect methodology to reach a just and reasonable rate.
But that's
And what-
saying it at a very high level of generality, because I mean, you're right. It's hard to quibble with what you've said. It was the methodology that led to the rate, but it was some particular things about that methodology that were identified as being problematic vis-a-vis 531, and that also carried over to 551.
Yes, Your Honor, but and that is what I was trying to explain. The commission viewed itself as addressing those specific criticisms, specifically the Amerimain criticism of the commission using these alternative models just to vary the discounted cash flow result without using those alternative models to support the return on equity that it ultimately selected. That's a very specific criticism from Amerimain, and the commission was trying to address that very specific criticism in this case by using the alternative models, not just to vary the discounted cash flow result, but to support the ultimate just and reasonable return on equity that it selected.
Okay, unless my colleagues have additional questions for you, Ms. Perry. Thank you. Mr. Pomper, I think you had 6 minutes left in your argument.
Your Honor, I apologize. I'm also here to support FERC on.
Oh, I'm sorry. I'm sorry.
Intervener.
Yep, I completely overlooked you. Sorry, Mr. Bennett, you're up again.
Thank you, Your Honor, and may it please the court. Yes, we've also intervened in this case on behalf of FERC on certain limited issues. We did not brief the methodology issues either in support of FERC or taking issue with what FERC did. So I really would not be addressing those issues. Really what we're concerned about is the refunds. And it's really, as Judge Katz has pointed out, it's two sides of the same coin. You know, in this case, FERC ultimately addressed our concern on the back end, and we think it should have been addressed on the front end. But that being said, I do appreciate Judge Katz's asking the flip side question to Mr. Wolf, because I think it's an important one. But what I think is even more important is that in this proceeding, what the customers are asking for is pretty extreme relief. They've posited in their briefs, and I can give you a couple examples, page 11 of their initial brief and page 16 of their reply brief, that they believe this court should interpret the Federal Power Act to allow that a customer can lose on a complaint proceeding on the merits, but yet still obtain the remedy that they sought for that complaint. And they do that by twisting the words "any proceeding" to this expansive meaning far beyond that which could conceivably been Congress's intent. I mean, that interpretation defies both the language of the statute and the logic. I think it's important to emphasize that by receiving 15 months worth of refunds in the first complaint case for the 12.38% base ROE that was determined to be unjust and unreasonable, they received all the relief that they were entitled to under the statute. And the reason that is that the refund authority in section 206B is premised on the setting of a new rate, which happens under section 206A. Under section 206A, FERC must find a rate unjust and unreasonable, and then determine the just and reasonable rate to be thereafter observed and enforced, and then shall fix the same by order. Only once FERC has completed these steps can it even consider refunds. While Mr. Wolf indicated that FERC has discretion, it may grant refunds. It can't grant refunds beyond what the statute contemplates. So FERC can only grant refunds in a proceeding where it has actually ordered a new rate to be thereafter observed and enforced. FERC didn't do that in the second complaint proceeding because it dismissed the complaint. There can be no other interpretation than that. FERC made the determination that the MISO transmission owner's base return on equity was unjust and unreasonable in response to the first complaint. Once they made that determination, that's it. The rate has been declared unjust and unreasonable, and section 206A then starts the process by requiring FERC to fix a new just and reasonable going forward rate, and based on that rate, FERC can grant refunds. But it can only grant refunds for 15 months. It can't take the 12.38% base ROE that is just declared to be unjust and unreasonable, and then turn around and redeclare that rate that is no longer in effect because they declared it unjust and unreasonable a second time, and then turn around and use that as the basis for granting refunds in a second complaint proceeding. Now, turning to Mr. Wolf's concern about the length of time that these proceedings take, and that Congress surely never intended 5 years of no refund protection. I can sympathize with Mr. Wolf and his clients that this proceeding has taken a very long time to conclude. And if you look at the amicus brief, the timeline in that brief, New England's been facing this even longer than we have. But Congress made a deliberate choice to provide some refunds, but yet to insulate utilities from never-ending refunds. And Congress also included a safety valve in Section 206B. If the delay is caused by the utility, the customers are entitled to refunds for as long as the proceeding goes on. That didn't happen here. So Congress was aware that proceedings can take longer than 15 months. In fact, Mr. Wolf said that Congress thought about 2 years, and that's true. But Congress initially considered open-ended refunds. The House bill actually would allow for unlimited refunds. The Senate reined that into 15 months and then put in what I called the safety valve in the event that the utility is the reason why the case has been delayed. So Congress contemplated all of these issues and struck a balance, and what the customers are asking this court to do is upend that balance.
Thank you, Mr. Bennett. Let me make sure my colleagues don't have questions for you at this time.
No.
Thank you. Now, I believe, Mr. Pomper, you had 6 minutes left.
Thank you, Your Honor. I'd like to address the risk premium and the beta issues a bit, but I have to start by saying I'm a little bit nervous about doing that, because under the owner's position, if I persuade you that FERC was arbitrarily and capricious in its methodology, and that resulted in the rate being set too high, I'm actually worse off, because I can't get the reduction below 1238 until FERC deals with the remand. That's the logic of their position, which it's pretty convoluted, but that's how you get there. So I don't know if I want to win given that construct. However, I'll assume that that's not going to be upheld as the law and proceed to argue why there are arbitrary.
But what would be, I mean, if you do win, what would be the rate that's in place while things get worked out by the commission on remand?
Well, there's two issues about what is actually charged on a day-to-day basis in the interim, and then what can the remedy ultimately be. This issue arose in the New England case as the interim rate. And what FERC did there is they have left in place the same 10.57 rate that was at issue in Emerald, Maine, but they've said once we finally resolve the issues on remand, which they haven't done yet, we can either surcharge or refund to get the result to what it should have been.
Right. So as long as it all gets reconciled at the end of the day,
right,
I take it that everybody's okay.
That was I was also involved in representing clients in the New England case. We were okay with it there.
Okay.
And so that's where things sit at in the New England context. And here likewise, FERC had on rehearing issues very similar to the methodology issues you're seeing now on a rehearing of opinion 551. And then when Emerald, Maine came out, they said, you know what, there's something to these rehearings. We have to reconsider the methodology. And they wound up with the revised methodology that they have done here, but it was within the scope of what had been litigated earlier. We think there still are arbitrariness issues in what they've done. I'll get to those. But I think FERC has to have the ability to correct its errors, and not just legal errors on remand, but under the rehearing provisions of the statute, section 313. The statute is explicit that FERC on rehearing can correct any component of its orders that it finds should need correcting. So they can retain the effective date and change the number, which is what they did. On the details of the methodology, the risk premium methodology, there was reference to Dr. Moran. First of all, I should note that Dr. Moran is an expert witness for utilities. He's not exactly an academic source, but he's treated as such by FERC. He does not recommend or support in any way the use of the intensely circular risk premium methodology that FERC used here. There are risk premium methodologies in state commissions where the commission looks at all state commission orders across the country. And so It's not just looking at its own orders, which is what FERC did here. And what that did, among other things, FERC's settlements in the cases that were included in the risk premium data set bake in the errors that Remain found arbitrary and capricious. Because when utilities and customers reach settlements, of course, they're not just looking at cost, they're looking at what would FERC do. And at the time they reach these settlements, they have to say, well, FERC will probably set the rate at the top quarter of the DCF results. Even though that was later found to be arbitrary and capricious, that's in the numbers that feed into the risk premium data set here. That's part of the problem with the circularity. And that, in combination with the bond yield anomalies of the Great Recession and its aftermath, mean that in that study, it's supposed that ROEs stay exactly the same no matter what, or very close to the same no matter what happens to the bond yield. So there's no market input that acts as a circuit breaker and brings things back to the cost of equity. It's just a hall of mirrors about what the commission would do, including its errors.
Mr. Pomper, if I asked Ms. Perryman why FERC in 569A changed its mind about the risk premium modeling, I'm sure she would say they did it on the merits. They realized the errors of their way. They explained it sufficiently, et cetera, et cetera. Why do you think FERC adopted the risk premium modeling in 569A?
Well, I mean, I don't want to speculate as to motives. Commissioner Glick has spoken to motives in his dissents, and he's leveled the pretty forcefully stated charge that the commission was trying to back into a number. And it's interesting that they got to a number just over 10%. But I don't know. I'm not privy to those discussions, and I'll assume good faith.
That's fair. That's fair.
On the beta issue, it's important to understand what beta is. It's a measure of the relative volatility of one stock against a broad market portfolio. And so it just naturally follows that if you look at a beta based on the New York Stock Exchange, the New York Stock Exchange, being much more larger and more diverse, is not as volatile as the S&P 500.
But what about the argument what about the point that the commission makes that the data just wasn't available?
Well, the inference is certainly, permitted. There's substantial evidence based on what Louisiana put in about the 2019 data that there is a material difference when you do the beta based on one data set versus the other. And I think the commission could have made an inference that would also be the case in the 2015 data. Now, it is true that because the commission had said you need to use the value line betas, the study period data for the baseline value line was not put in because we were following FERC's instructions. But they could have reopened the record for that. They could do that on remand, or they could make a judgmental inference from the 2019 data. But it does logically follow that when you compare it to a more broadly based index, the relative volatility of utilities is lower when you compare it to the S&P 500. That would have been consistent with what they did on the growth rate. Let's take it back again to that growth rate that they use is just way higher than anybody else uses. And I think, frankly, I think any investor, and judges are investors too, you have to ask yourself, would I be happy with knowing that I'd be earning 12% on an index fund forever? You'd be very happy. That's not what has happened historically. That's not what anybody expects to happen prospectively. It's just FERC's unique methodology here, where they only look at the short term and assume that continues forever, even though they said that's inappropriate. That's how they get to such a high number. And that's the tentpole of the capital asset pricing model. You're basically going to get to a result very close to whatever you assume the market's going to return, and they've got an unrealistically high number that has not been explained. Of course, I'm not asking you to reverse them because they got to the wrong number. It's a question of, was the methodology arbitrary and capricious or adequately explained? And here it was arbitrary.
Thank you. Let me make sure my colleagues don't have additional questions for you, Mr. Pomper. Thank you. Thank you, counsel, and thank you to all counsel for your arguments this morning and stretching into this afternoon. We'll take this case under submission.
This honorable court is now adjourned until Tuesday, November 30th at 9:30 a.m.